What is a back-to-back transaction? Why it arises and why it is so commonly misunderstood. Hello, this is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. Let's begin with the basic point, because this is one of those aircraft transaction terms that sounds informal but carries serious legal consequences. A back-to-back transaction is not one sale. It is at least two separate sales, usually closed in sequence or simultaneously, in which an intermediary acquires the aircraft from one party and then resells it to the ultimate buyer. NBAA's back-to-back transaction primer describes the structure in essentially those terms. The intermediary, often a broker, dealer, or a market participant, buys from the seller and sells to the end buyer. Aviation International News, through the National Aircraft Finance Association, similarly explains that these structures can involve one or more intermediaries and sometimes multiple links in the chain. So the first lesson is simple and memorable. If there are two contracts, two prices, and two transfers of title, you do not have a colorful variation of a normal deal. You have a different legal animal. Why does it arise? In large turbine aircraft, it arises for practical reasons. Inventory is thin. Buyers want access to off-market airplanes. Sellers may want a fast, certain number without negotiating every downstream issue. Intermediaries may have relationships, market intelligence, import capability, refurbishment capability, or a willingness to take price risk for a spread. Sometimes the intermediary is solving a timing problem. Sometimes it is solving a confidentiality problem. Sometimes it is solving a tax, registration, or repositioning problem. And sometimes it is simply monetizing information asymmetry. That is why these transactions are common enough in today's business aircraft market to be familiar to sophisticated brokers, title companies, escrow agents, and transaction counsel. Even if NBAA correctly notes that they are not historically the standard structure and have become more prevalent more recently. In other words, they are not exotic anymore, but they are still dangerous when they are treated casually. Large turbine aircraft make the danger more severe. The dollars are larger. The due diligence burden is heavier. Engine programs, maintenance tracking, damage history, interior completion, supplemental type certificates, enrollment status, export issues, financial conditions, and registration timing all matter more. A Gulfstream, Global, Falcon, Challenger, or large cabin Embraer is not a commodity widget. Every one of those aircraft carries a document history, a maintenance story, and often a tax and financing story. So when an intermediary steps into the chain, it is not merely stepping in between two parties. It is stepping between two compliance narratives. Here is something I'd like you to take away from this. And remember, in a large turbine aircraft back-to-back transaction, the spread is earned in the gap, but the liability also lives in that gap. The next thing people misunderstand is that the intermediary is not automatically doing anything improper. A true dealer or trader can lawfully buy and then lawfully resell. The law does not prohibit profit. What creates risk is incomplete authority or a structure that is represented one way but functions a different way. If the intermediary never truly controls the contractual chain, cannot deliver the aircraft, lacks the ability to pass marketable title, or is hiding critical facts about condition, ownership, or price mechanics, the deal moves from efficient to unstable very quickly. Federal law explains why. Under 49 U.S.C. Section 44107, the FAA maintains a recording system for conveyances affecting interest in civil aircraft. Under Section 44108, the validity of those conveyances against third party turns on recording rules. And the FAA registration application instructions make the practical point unmistakable. If the buyer is not purchasing from the last registered owner, the buyer must submit conveyances completing the chain of ownership from the last registered owner to the applicant. That means that the aircraft registry is not interested in the commercial story. It is interested in the documentary chain. That is why I tell clients this: a back-to-back structure is only as strong as the weakest paper in the chain. In a large turbine setting, that paper weakness can hide in several places. It can hide in the first purchase agreement, where the intermediary has weak assignment or closing rights. It can hide in the second agreement, where the end buyer is promised delivery standards that the intermediary cannot force the seller to satisfy. It can hide in the escrow instructions, where funds are timed incorrectly. It can hide in the title package, where releases, trust documents, or registry filings do not line up. And it can hide in the records room, where intermediary promises access it does not actually control. That is why good back-to-back starts with one blunt question: who can actually cause what to happen and when? If the answer is vague, the deal is already telling you where the dispute will come from. And in the large turbine world, those disputes are rarely small. They involve 7 or 8 figure assets, inspection findings, maintenance reserves, engine exposure, and reputational damage in a very concentrated market. In short, the first thing to understand about back-to-back transactions is that they arise because they solve real market problems. They are not rare curiosities, but their legality and prudence depend on disciplined, structured, real authority, and a documentary chain that can survive scrutiny. I'd like you to take this away and remember this. In large turbine aircraft transactions, a back-to-back deal is not risky because there are 2 closings. It is risky because there are 2 chances for reality and paperwork to diverge. Thank you for your interest in this topic. This information is provided for informational purposes only and is not to be construed as legal advice. If you have any questions, they are certainly welcome, and you can address those to admin@aviationlegalcounsel.com. We look forward to helping you navigate these issues with precision.